Welcome to Real Clear Radio Hour. This is your host, Bill Frezza. Today we'll be talking to George Mason University Professor of Law and Economics, Tom Hazlett, an expert and historian of telecom regulation. We recently observed the 100th anniversary of the creation of the Bell System monopoly and the 31st anniversary of its unwinding. With an increasingly aggressive FCC seeking to expand its powers, we thought it might be worthwhile to take a look back at the impact Washington has had on both promoting and stifling progress. Tom, welcome to the show.
Thanks for having me.
Tom, we're celebrating the 100th anniversary of something called the Kingsbury Commitment. This is a consent decree with the Justice Department that established AT&T as a monopoly. Back in the early days of the telephone business, when it was swarming with competitors, AT&T had pulled ahead of the pack, had developed a long-distance network, seemed to be emerging as the big dog in the fight, and of course was set upon by the trustbusters of the time. And to satisfy the government, they made an agreement called the Kingsbury Commitment, which set off 70 years of government-sanctioned monopoly of the telephone industry. When I grew up, it was illegal to own your own telephone. I talk to college kids all the time, and they're shocked when they hear this. It wasn't until 1982, with the breakup of the Bell system, that we went on a rocket ride of innovation. We saw 30 years of incredible advancements in the internet, in smartphones, in all sorts of means of communication. You and I are talking over Skype right now, which would have been an impossibility in a monopolistic system. With all these benefits, we still seem to have a lot of pressure coming from certain segments to re-regulate the industry, to set rates, to make demands about net neutrality, and to change the way the market presents services to customers. Where do you think this is coming from?
Well, there's a well-established dynamic here, and that is that once the government sets out to regulate a very important sector of the economy, you're going to naturally have people picking teams, dividing up according to various interests and attempting to gain influence over the way the rules are pointed. And those teams will be composed of people who in many cases are very well compensated, whether or not they win. Even the losers make out because you have a game in which it's not just how you compete for customers in the marketplace, it's how you compete for legislative favors in the public sphere.
And I guess even congressmen who lose win because they use it as an opportunity to do more fundraising from the team who's on the temporary losing side. And so all built into the business model is pressure to regulate creates opportunities for regulators, congressmen, and companies and lobbyists.
Yeah, I mean, one of the ironies is that one of the most profitable ventures you can have in the public sphere is to be a policymaker who supervises a highly unsuccessful regulatory scheme. Because not only if you're one of the top policymakers, like a senator or a congressman, not only can you convene hearings to get to the bottom of the mess and hold the wrongdoers' feet to the fire, because there'll always be people to blame for the mess, particularly if you're looking at public sector actors that are of some size and, in public reputation. There's always going to be some ability to generate or ride backlash. But you're going to have a very complicated set of rules where private sector folks are going to have to come to the experts to figure out how to negotiate those rules. And those people who have been on the inside creating the rules have created human capital that they'll be able to amortize at a very generous rate in many cases. I mean, you're seeing this, of course, with things like financial regulation now, where Securities and Exchange Commission employees, lawyers in particular, are setting up or expanding very lucrative practices in guiding the so-called regulated sector, so-called because regulation is not some autonomous exogenous thing that descends on the system. It's really quite organic. It develops from above and below simultaneously. So
along the way, it creates all sorts of jobs. I mean, and these are high-paying jobs. Wouldn't some say that this is good for the economy to create all these jobs?
Well, I mean, the whole thrust of human history is to try to eliminate unproductive jobs.
But they all count in whether they're productive or not, they count in the GDP.
Well, yeah, they do. That's because of the funny accounting rules. But yeah, no, we have enough jobs. We just don't have enough productive jobs, and we have too many unproductive jobs. That's been so since the dawn of man, and will continue to be so as long as there are men and women grappling on this earth. So the fact is that if this is the sort of regulatory structure that does not produce net benefits, it is possible for regulation to do that, but we have lots of experience with rules that don't. If you're in a situation where the rules on average are lowering output because we do much better without so much supervision, then of course these are not productive jobs.
Well, there certainly was a time when the FCC moved to spectrum auctions and freed up big swaths of spectrum to create the cellular industry. I was on the front lines at the time. It was considered very innovative to actually go to market and have people bid on spectrum to build out systems. How's that working out?
Well, there have been some successes. And so we really need to start there. That is to say, from the dawn of the Federal Communications Commission, in fact, go back to the Federal Radio Commission that preceded it, that was crafted in the 1927 Radio Act. So we've been doing this for over 80 years now. The pro forma way in which the government would assign rights to wireless companies to provide services was to have very specific rules baked into a license, and then it would assign that license on the grounds of what the government considered to be public interest. Now, this just turned into a political beauty contest, of course, and lots of non-arm's length transactions sullied the waters. Famously, Lyndon Johnson became the wealthiest post-war president in America by his access to radio and television licenses as per his supervisorial role, so to speak, in the United States Congress and later in the White House. And so, we had a lot of inefficiency, as well as a lot of cronyism in the way those licenses were awarded. So what happens finally in the 1980s, when we got past broadcasting, that's sort of a side story on this, when we went to a point in time where the important new industry was wireless telephony, a common carrier services where there really is no content that the government can
regulate,
can control. The government had much less interest in it and much more interest in just getting the technology out and working in the marketplace. And so it didn't take too long. It took a while. I mean, the first generation of cellular was given out by lottery, but the second generation of cellular in the United States, starting in 1994, those licenses were issued by auction, competitive bidding. And the system worked very well. For decades, we've been told it was impossible to do this. You couldn't have wireless licenses defined so that the market could assign the rights. And that was just silly. There had always been secondary markets for radio and then television licenses. And we had always seen this happening, that the market was allocating rights. It was the actual allocation of the rights themselves, however, that was really holding up progress. And in fact, that system has not been reformed. We still depend on the government to create those licenses that are sold. And while the licenses for mobile services have become much more liberal and allowed much more what we'd call market allocation of the underlying spectrum, there's very little spectrum assigned to those licenses. The vast majority of the airwaves are still bottled up in top-down, what some people call Gosplan authority. And the government determines exactly what is done with those airwaves.
Considering how much money there is to be made in those auctions, you'd think there'd be someone on the government side, particularly looking at budget deficits, that would be very incentivized to free some of that spectrum up.
Well, you think, but actually there's a lot more going on than deficit reduction. I mean, this idea that deficit reduction motivates congressmen and senators is sadly quite overblown, because I say sadly, some extra discipline probably would be good for the U.S. federal government. But the fact is that the interests of congressmen and senators, presidents, is to do a lot of things, only one of which is to reduce the deficit. And in essence, most of those other things
crowd out.
Take precedence and give people these political incentives to pursue other agendas. So there's been only a soft kickback from the idea that, well, there's a lot of money to be had. We're leaving a lot of money on the table. Let's sell some of these licenses and get the spectrum out in the marketplace.
But aren't these opportunities for creating tiebreakers? I mean, every time you get into one of these 11th hour budget negotiations and one side is saying, I'm not going to give you that extra budget money unless you find the money from somewhere and know you can't raise taxes. Every time that happens, isn't there an opportunity to go out and sell some more spectrum, just as if you were selling any other piece of federal property?
Well, but first of all, that's not what they do. They don't sell spectrum. They sell licenses. And to get the licenses that they can sell, we still rely on regulators, 5 appointees of the president, confirmed by the Senate, to sit down and take a look at what they consider the inventory to be.
Uh,
And there's always some alternative uses and legacy licenses or government authorizations that have been sprinkled around these bans. And so it always comes to a political bottleneck where the regulators have to be the ones to, in essence, initiate a very lengthy impediment or barrier strewn pathway with all kinds of political detours possible to actually run the spectrum through the gamut to get it to the point where licenses can be sold. And even when they're sold, by the way, if somebody really did want to maximize revenue, they would sell very few licenses. Why? Because the monopoly outcome in the marketplace actually would fetch
higher
a higher
prices.
price than the competitive bid.
Yeah, I suppose that's true. Now, wouldn't freeing up poorly used spectrum go quicker if you gave the existing users a piece of the action? For years, the UHF spectrum was tied up by broadcasters, very thinly used, not a lot of economic activity in that area. I mean, if you remember your old rabbit ears, most of the UHF spectrum was snow. Why not just cut them in and say, just as you would if you're selling a piece of property, you're living there now, we'll give you 5% of whatever we get for this?
Well, that's what, in fact, since 2010, that has been the central idea of an official policy of the Federal Communications Commission, which they call incentive auctions. And in general, the idea that we need to get more liberal licenses, liberal in the sense that the spectrum that is authorized for use in the license has very few restrictions put upon it.
Mm-hmm.
And therefore, the market is basically dictating through consumer demand and the available technologies
What to do with it.
where that spectrum is used and how. Those liberal licenses should be moved into the marketplace much more aggressively. They cite appropriately the mobile data tsunami that's resulted from the mobile market already, particularly the smartphone revolution. Now, that's all come about due to liberalization. People don't understand that the Apple iPhone, which is this iconic wireless device, was not approved through an FCC rulemaking process the way that television set technologies are approved. And that's exactly why you've had this amazingly rambunctious and beneficial, socially beneficial innovation process in mobile that you never got in the television sector. I mean, now we are getting some progress through cable and satellite, and the digital panels and flat screens and so forth that people like have come into the market almost entirely through connections with cable and satellite, which is a deregulated aspect of that market. Mm-hmm. So there has been a substantial liberalization over the last 30 years, and you reference it some by way of going all the way back to Kingsbury and seeing the fading away of monopoly through both an antitrust policy that went towards monopoly 100 years ago, and then an antitrust policy that went the other way in the early 1980s. But there have been other important parts of this liberalization, particularly in spectrum policy, that have led to very robust, innovative growth. And we want more of that.
So there's some success stories. Where else would you apply it if they made you poobah of the FCC tomorrow? Where else would you institute flexible licensing?
Well, in general, I'd do it everywhere. Now, that doesn't mean you're going to kick out the incumbents, because people have invested billions upon billions of dollars in wireless devices that should, continue to operate and be given some deference unless there's a good reason, an efficient reason to change, meaning the benefits of the change are more than the cost of the change. So in general, what I do is I'd issue secondary rights to the non-liberalized parts of the spectrum where you have incumbent users that either have traditional licenses that allow them to do just one particular thing with wireless, and government users. And this is really where most of the spectrum is used up in very low-valued applications by the Department of Defense, the Department of Commerce, the Department of Agriculture, and on down the list, because for the exact reason you'd expect in your Econ 101 class. If you give somebody a valuable resource and don't attach any economic ownership to it, just say you can use this and you can use it in a particular way, but you can't do anything else with it. You can't sell it to somebody else who might offer you a good price for it. You can't turn it into some different use and capture the economic benefits from that. If you quarantine just totally out of the economic incentive system, you quarantine this resource, you're not going to see it go to its highest valued
Well,
use.
so why not take the Commerce Department and the Department of, Indian Affairs and whoever, and if they are using spectrum, hand them the deed and say, use it or sell it. It's up to you. If you sell it, you can keep the money and put it in your budget.
Well, first of all, that's illegal. Secondly, to make it legal, there's no obvious pathway. You can't have government bureaucrats running off with government resources and putting their proceeds in their pocket. By the way, that's to some extent, that's what happened in Eastern Europe after the fall of communism. You had the apparatchiks, the Communist Party insiders running off with a lot of the
But they put it
resources.
in their personal pockets, put it in the department budget. These departments are supposedly under budget stress. So,
Right.
basically push to the periphery. Instead of
Yeah.
having Congress decide to sell off national assets, let the department sell off assets.
Well, no, you can't do that either. And you can't do that either because the department doesn't own those resources. They get allocations every year in the federal budget, and the Congress knows where those dollars are. And the Congress will reallocate away from an agency that's actually gotten a windfall in this fashion. And this is quite standard. Let me give you an example in another area. Many of the U.S. states now have lotteries. And in each lottery, the object is to actually raise money for schools. The money is dedicated to schools. So there have been numerous studies done. Do the schools actually get the money?
Mm-hmm.
And consistently, the answer is no. If you look at funding for the schools with and without the lottery dollars, it's just absolutely flat. There is no marginal impact. That is to say, if there is money going to the schools because of the lottery, the legislature reallocates away from the budget and sends it to other things.
Yeah, money's fungible, and they can move the shells around in the background, and I guess that absorbs all the value. So why bother?
So what happens here is within the public sector, you can't write the contracts. What you've said to me is, why can't there just be a contract, an agreement that the agency gets to keep some money if it contributes to a good solution? Well, obviously that's what you want to have happen, but you can't have it happen in the public sector because those contracts are not available to you. You've got rigid red tape and rigid rules leading to red tape. And the red tape's there for a reason. As I said before, you don't want bureaucrats running off with the
assets,
the jewels. But the upshot of that is that you've got rigidities in the system by virtue of this state-run allocation of spectrum to begin with. That's why this is such a dangerous path to embark on. You really do set yourself up for a lot of problems down the road.
So what would you say is on the front burner right now in telecom regulation? I mean, we keep hearing about net neutrality. This is a fight that I certainly remember back from the 90s and seems to come around every 3-4 years. A bunch of constituents are clamoring on one side or the other. Various players in the industry line up on one side or the other. Where are we today? Give us a scorecard.
Yeah, not to correct you, Bill, but you don't remember net neutrality from the 90s. It had a different name. It was called open access in the 90s.
Yeah,
so it's
right.
got a new name now.
Right.
It's called net neutrality. It's completely different, but completely the same, of course. And indeed, it's a form of common carrier regulation that goes back not just a decade, but hundreds of years. And what it tries to do is treat broadband providers like a public utility. And it really starts with what seems, unfortunately, to many people is a plausible thesis that the broadband provider should just provide the connection to the internet. That's it. It's called the dumb pipe theory.
Yep.
Okay, so if the broadband provider, whether it be Comcast or Verizon or AT&T or any other ISP, if they actually try to give you some content that they have maybe a special deal with some website, or they have their own proprietary content, or they got some applications or services they want to package, maybe bundle into your monthly bill, that inherently will force them through their economic incentives to discriminate in favor of their own services coming in on the pipe and against all the thousands or millions of edge providers trying to compete with their own applications. So the idea is that it's just too dangerous to allow these broadband ISPs, internet service providers, to do anything more than be a broadband internet service provider.
Yeah, but they built the pipe, right? They weren't handed the pipe. They built the pipe.
Yeah, that's why in net neutrality, much of the argument is first assume a network.
Right.
And it is sort of funny. The fact is, though, that when people look at these actual markets, what they find is not only is it not true that these particular companies built the pipe, these particular companies have long collaborated efficiently with so-called edge providers, those putting out the applications and content that make that pipe valuable. I'll just give you one quick example that's one of my favorites. In 2002, well before it was a public company, Google actually had an existential corporate decision to make. They had negotiated with AOL, which at that time was the world's largest ISP, and had considerable market power as per the Federal Trade
I
Commission.
remember the days, right?
In the year before in the AOL Time Warner merger. And Google had a deal. They were this upstart search engine. And before their IPO, they did not have cash. They weren't strapped. They were doing fine as a startup. But they had a deal to make with AOL where if they paid a considerable amount of cash, which was basically everything they had in the bank, and a percentage of future revenues, AOL would give Google search the default position for the search engine on the AOL startup page.
Mm-hmm.
And within Google, there was a heated debate between the three reigning decision makers. And of course, two of those are the famous kids from Stanford, Brin and Page.
Mm-hmm.
And they were totally in favor of this. And the adult supervision they had brought in, Eric Schmidt, who was supposed to know how to run a company, he was totally against this. He said, look, this is too risky. It will jeopardize, the entire future of our company. We just don't have this kind of money to throw around. So it turns out the younger kids, said, well, thanks, Pops, but you don't really understand the business model here. When we go on 34 million new startup pages every morning, Google search is going to take over the world. It will be gangbusters from that point forward. That's the scale we need. We have to pay. And sure enough, they outvoted the old man. And the rest is history. It was a hugely successful, in fact, it's referred to as the most important corporate decision in the history of Google in a couple of business histories of the company. And they went on to fame and fortune, the rest is history. But the point is this, whether it had failed or not, this is a very standard way that upstart application providers actually get in by making deals of this nature with ISPs. There's nothing nefarious about it. It's part of the competitive marketplace. And to put your foot down and say all of this innovation has to stop. We're going to tell you what the business model is. We know better. We're not going to allow any flexibility is really not only the height of arrogance, it shows a fundamental misunderstanding of the internet. And by the way, it shows a fundamental misunderstanding of U.S. regulation, because U.S. regulation does have antitrust law. And if there actually is anti-competitive foreclosure, which is the claim of the harm under net neutrality violations, you do have both the Department of Justice and a Federal Trade Commission, two expert agencies that are there to represent the people in any antitrust suit that might develop.
So if broadband ISPs are not permitted to monetize their network assets as they see fit, why would they invest more money in those assets?
Well, they'll invest less. There's no question. And I should say that people, of course, when they're talking about net neutrality and proposing this as some kind of a solution, they're searching for a problem that's going to be posed in terms of the great multinationals and the Comcasts and the Verizons. The first net neutrality complaint filed under the rules, which were passed by the Federal Communications Commission in late 2010, the first violation was against the ISP, the wireless ISP, called Metro PCS. Now, many people have not heard of Metro PCS. They were the fifth largest wireless company in America, and they had a bargain basement deal, $40 a month, all you can eat. And this was data, text, and voice. But it was only 2.5G. It was an older network, and they had to actually limit the video streaming, because video streaming would have eaten up the capacity. So what happened was they got a more inclusive offer together. But by the way, they had a $60 a month offer that did give you video streaming and no restrictions. But on the 40, you couldn't do video streaming. And I should say, I don't think you could do peer-to-peer voice like on Skype, because it, again, was a bandwidth capacity issue. So what happened is that Metro PCS went to Google, the owner of YouTube, and they said, our customers, particularly our $40 a month customers who tend to be young, They really like YouTube videos. We can't deliver them on our $40 a month package because of bandwidth constraints. Is there some compression technique that you can come up with that would get those videos to our handsets without eating up network capacity so much?
Mm-hmm.
So these Google engineers said, yes, we can do that. Of course, they perform magic, I guess, on a daily basis out there. And boom, they come back and say, here's a better way to do this, and we'll get the the YouTube videos to your handset. So sure enough, Metro PCS advertises to its customers unlimited YouTube videos, all you can eat everything else, but no video streaming,
Mm-hmm.
$40 a month. In other words, they give customers an extra service, which is unlimited access to YouTube videos. Why were they complained about in the net neutrality rules? Well, first of all, the FCC actually noted this in their rules, saying this looks like a violation to us. This is discrimination. What's wrong with Hulu? What's wrong with Yahoo videos?
But isn't the easy answer, if they want to use this compression scheme, they're welcome to come aboard?
Well, they didn't have the compression scheme. I don't know if Google was willing to run over and help its competitors. The fact is that Metro PCS had no interest in Google. They're not, they're helping Google, I guess, get to the handsets with the YouTube videos. But they just wanted their customers. It's demonstrable. They just wanted to make a better deal for their customers.
Yeah, wanted their customers to be happy.
To compete against, AT&T or Verizon and the other wireless companies. So for offering a better, more inclusive deal, more for your buck, they were immediately hit with a complaint under the net neutrality rules. And it was a complaint that did not come out of left field. It was actually found in the notes of the actual FCC order on net neutrality, saying this looks to us like an anti-competitive violation.
So open season on these guys. Go get them.
That's right.
And what happened?
Well, a couple of things happened. First of all, the net neutrality rules have been challenged in court by Verizon and by Metro PCS. That is to say, they accused the FCC of regulating where it had no jurisdiction, going beyond the bounds of the 1934 Communications Act. That case is still in court, and a decision is expected momentarily. Most observers think that there's a very good chance the rules will be thrown out, that the plaintiffs will be successful. Along the way, however, Metro PCS has been acquired by another wireless carrier and has dropped its suit against the FCC because at this point it's not Metro PCS's problem. Now, to the extent that Metro PCS was a small company fighting for market share, they had 1/10 as many subscribers as Verizon. To the extent that they actually had to expend costs on litigating against the agency and defending themselves, sure, one of the reasons to be acquired by a larger company is to get out from under that cost structure.
Well, heavy regulation always leads to consolidation. That's like one of those laws of the universe.
Yeah, there it is.
And we've seen it in banking. It's going to happen in healthcare. It's just too expensive to engage with the system if you're small or a startup.
Yeah, I don't think it's the only reason, because there is a consolidation for access to spectrum. That also helps their economies of scale with regards to the spectrum use. But there's no question that this goes in that direction.
Wasn't Comcast whacked for throttling bandwidth hogs?
Yeah, it was 2007.
And what happened to that?
Well, the FCC came down on them. By the time they came down on them, they had already negotiated with BitTorrent, which is the company that they were having a problem with, flooding the zone, so to speak, because the peer-to-peer applications do try to soak up, quote-unquote, unused bandwidth. It becomes a contested issue at some point, and IT managers, network managers in general, do not like peer-to-peer applications for that reason. At any rate, Comcast negotiated an agreement, so to speak, sort of a standard way of handling the congestion problem with BitTorrent, and that was already worked out. And the problem moot by the time the FCC ruled against Comcast. The Comcast ruling was then taken to court, and Comcast won in the federal court, showing that the FCC did not have jurisdiction to impose any regulatory sanctions on Comcast, that they were, again, completely beyond their jurisdiction.
So there seems to be a theme here of the FCC acting beyond its jurisdiction. What's that all about?
Well, this is, you spin the agency into orbit, and, they're going to want to keep momentum, and they're going to reach out and touch someone. They're constantly being approached by interests that are in favor of regulation being applied against new competitive rivals, certainly. And there's some political benefits sometimes in going out and regulating someone if it can be the generator of positive headlines, protecting consumers, protecting innovation. However, it will get spun. It doesn't make any difference what the actual effects are. If you can get favorable headlines on it, that can be a political incentive. And so the agency itself, and this is true generally, not just the Federal Communications Commission, is looking almost in entrepreneurial fashion, looking for where it can open up new initiatives and prove to be quite popular. So, I mean, the classic is 50 years ago, way back in 1961, when the most famous speech ever given by a U.S. regulator was given in Las Vegas to the National Association of Broadcasters, the television and radio licensees, by the FCC chairman, Newton Minow. And Minow, confronting this room of broadcast executives, said, I've watched your product. It's a vast wasteland.
Yeah.
And the vast wasteland speech is still fondly cited and generates positive headlines 50 plus years later. In fact, the chairman, who threatened to come up with new forms for renewals of licenses of TV stations to try to clean up the problem, never did come up with any new forms. Business as usual, except no sooner did Minow return from Vegas to Washington, D.C., than he began carrying the water for the television broadcasters who, at that point in history, it was a very critical moment, were apoplectic about the possible emergence of a real competitor in video markets, cable television.
Yeah.
And so starting in 1962 and reversing dramatically previous FCC policy, which was laissez-faire on the matter, the Federal Communications Commission began about a 15-year jihad against cable TV. And only in the late 1980s, when that was eliminated, all those anti-cable rules were abolished, did you see the actual wiring of America and the emergence of C-SPAN, CNN, Fox News, Discovery, all these competitive networks that now give us much more than a vast wasteland. And that only came about when the argument for the vast wasteland was actually put aside, and those who had crafted that very popular public argument about how terrible things were had long gone from the scene, and new blood had reversed their policies.
Well, I was in the industry back in the early 80s working at a firm called General Instrument that was doing all the set-top boxes, and I lived through most of the franchise wars. Remember at the time, the action, once it broke out, was at the metropolitan level because each city was granting exclusive franchises to operators who would then get a monopoly in return for guaranteeing to wire the whole city. Yep. And there was a decade of really incredible activity and notorious corruption in the process. I mean, not only the biggest liars winning the franchise, promising services that were never delivered, but all sorts of backroom deals and money in the pockets, and several people went to jail that I remember working with. Cities carved up and handed to the mayor's friends. I mean, it was a pretty frenzied time.
Yeah, well, with federal deregulation, you unleashed cable, and they were wiring America. Mm-hmm. But that's when, in the late 70s, early 80s, the political shenanigans shifted to the municipal level.
Yeah, they get even dirtier on the municipal level because bags of cash don't have to go as far.
Well, the CEO of the largest cable company in the country, Teleprompter, in the late 1970s, Irving Kahn, one of the real pioneers of the cable industry. Kahn went to federal prison for bribing the mayor of a town in Ohio. Curiously, the mayor did not go to jail. Anyway, yeah, no, it was quite wild. But the real scandal was how few scandals resulted in criminal penalties, because you had monopolies created, by and large, and you had political groups being given stock in companies to, in exchange for lobbying for the franchise.
Oh, it was a great way to get rich.
And they were called rent-a-citizens. Yep. This was a standard term of art.
Yep.
And in fact, they weren't rented. They were bought outright. They were given stock that could be cashed for the capital value that was created. Yeah, these were wild and woolly times. At the end of it all, however, you did get America wired for cable. You got a tremendous expansion of the television market, competition, including in informational programming, which is so important to a democracy and is constantly being pointed to as the reason for Federal Communications Commission regulation. Well, that exploded, but it exploded on the unregulated medium. Okay, C-SPAN is not licensed. CNN is not licensed. Neither is MSNBC or Bloomberg or Fox News or any of the other cable networks. And so these unregulated alternatives, the broadcast,
really
the
changed the
licensed
scene.
media, have really produced a cornucopia of free speech. And that's been tremendous for democracy.
So some of these battles do come into the modern age. I live in Boston. Verizon has been trying to bring Fios, their broadband fiber network, into the city for quite some time. And my understanding is they've been blocked because the mayor will not let them wire up the most lucrative neighborhoods first. The mayor is insisting on a commitment to wire the whole city. And
Right.
it's just not cost effective to take this fiber into less dense, less affluent areas because they don't see a return.
Yeah, well, this is where you get into the finer points that are so easily manipulated by incumbents. So you will actually see some incumbents in a market. In this case, they'd be cable TV operators. They will say things like, well, we don't mind competition as long as they compete with us everywhere.
Right.
Well, of course, that's disingenuous. If they're going to have competition, they want as little of it as possible. And the fact is that they know it's a barrier to entry to tell the entrant, look, there's already a company or two or three serving this market. If you want to be the nth server, you've got to do the most expensive, least dense parts of the market first. And that's a good way to make it impossible to justify any of it.
Well, that's exactly what's happened here. That's why I can't have Fios.
Yep.
Tom, it's been delightful taking a romp back over the last 100 years and listening to your tales of how the industry has changed and yet still remains the same. Thank you for being on the show.
Well, thanks for having me.
Well, that wraps up another episode of Real Clear Radio Hour. We've been speaking to George Mason University Professor of Law and Economics, Tom Hazlett. This is your host, Bill Frezza. Thanks for being with us.